Our top story this half hour, Alex-Murdaugh, along with his defense team and prosecutors, appeared in court for another retrial hearing. Judge Debra McCaslin ruling on several motions today. She granted the defense's request to begin independent testing of DNA evidence that was recovered from Maggie Murdaugh's fingernails. She also approved a change of venue for the murder retrial and is now moving it out of Colleton County.
And went through and did some work on them. And I'm going to tell you, after reviewing the motion submitted by both sides, I even went back and looked at the transcript of the jury selection that was conducted back in January of 2023, and also the opinion from our Supreme Court. I'm going to order that venue be transferred to a county outside of the 14th Judicial Circuit, because I believe that the defendant cannot receive a fair and impartial trial in Colleton County.
The judge also ruling that Murdaugh's testimony from his prior trial now may be used in this new retrial based on what is being testified. News 19's Whitney Sullivan will be sitting down with criminal defense attorney John Mobley as well as Dane Phillips to be discussing that specific part of the ruling. Take a listen.
I mean, their client's a liar. I mean, it is what it is. I mean, I can understand why they want to keep it out, but I mean, you know, he admitted during the first trial that he lied to the police. Mm-hmm. And what's significant about the first trial that I recall specifically is that he didn't just lie to the police, he lied to his own lawyers, because in an opening statement in the first trial, the defense opening said that the defendant, their client, did not commit the crime because he had an alibi and he was not there. Then he testifies during the trial on the witness stand that he lied to the police that he was there. So not only did he lie to the police, but he was lying to his own lawyers up until the day of trial. And the reality of it is this: their client, I'm not saying he's guilty of the murder. I mean, the evidence is circumstantial at best, I would agree, but he's a liar. I mean, it is what it is, you know, and they're going to be stuck with it. And, you know, so I think that's one of those things that, you know, their client kind of created that dilemma for them, and they've got to come up with some reasonable way to try to somehow take the sales out of that. And, you know, which is a problem because, I mean, the financial crimes, his reputation is already horrible. I mean, you know, it's like representing the devil. I mean, this guy, he stole from clients, his partners, he stole from children. I mean, he's just a very dishonest person. And that was just, you know, I mean, he just dug himself in further by admitting lying to the police about the murders. So, I mean, that's something they're kind of stuck with, that they got to figure out a way to kind of manage that to try to somehow take the sting out of that from the jury, who's going to already have a bias against them for being a dishonest person.
Well, it's more of the legal issue. And again, as I also do appellate work, so I get so focused on the legal issue. The legal argument the defense has made is there's this case Harrison that they made, and there's a very good record from the first trial in the defense's motion where the defense made it clear his decision and their advice as from his counsel was based on the fact that they allowed in all of that financial crimes, that you had essentially 10 days or 12 and a half hours of financial crime evidence that was presented. And that was a pivotal reason for why he made the decision and why his lawyers advised him to testify. And because the Supreme Court has said that most of that financial crimes evidence should be limited in scope and was not admissible, that would change his ability to make that decision in the moment that he was responding to the state's evidence. That is a strong argument. The issue is I don't have a problem with them using it as impeachment. If he was to testify again and he changed his testimony, then they could cross-examine him and use it as impeachment. But to use it in the state's case in chief, I disagree with, and I think it creates another appellate issue that we have to deal with when you don't have to create another appellate issue in a case that's already on a retrial. Because again, the right to testify is certainly a deeply rooted constitutional issue, and whether we're using essentially testimony in the state's case in chief where it's not responding to his testimony, to me creates an appellate issue that is not needed in this case.
Just a prophylactic motion.
Now, the next hearing is set for Friday, November 13th. To watch today's entire pretrial hearing, you can stream it right now for free on WLTX.com. And don't forget, you can watch our entire After Hours series. That's coming up tonight on WLTX Plus at 9 o'clock.